everyone to the Pennsylvania legal landscape of products liability, where the brilliant Larry Coben and I have been doing a series of webinars where we're covering all topics products liability in Pennsylvania, and having these brainstorming sessions with you and sharing information. Last time we covered the elements and types of products liability cases. We talked about tincture and went through all that. That video and materials are available on the Anapol Weiss website and my website. Next time we'll be talking about identifying and investigating products cases, which will sure be a fun one. But today we're going to talk about jurisdiction and venue in defenses in products liability cases. And Larry is going to get us started on the topic of the day and everybody's, or at least the defendant's, favorite topics over the last 5, 6, 7 years that's reared its head in jurisdiction in product liability cases.
Okay, Jamie, thanks again, and greetings everyone. Hopefully what we're doing here will at least inform and provide up-to-date information that is always relevant in every products liability case, one way or another, particularly under Pennsylvania law, which seems to continue to evolve through our appellate courts almost on a daily basis, as we'll be discussing today. We'll start with jurisdiction. Jurisdiction, until the last several years, seemed to have been a rather settled issue until the U.S. Supreme Court began to chip away at defining jurisdiction, both in terms of both what we call general jurisdiction and specific jurisdiction. And general jurisdiction, which is something that we consider all the time in products liability, relates to having jurisdiction over a product manufacturer based upon that company's place of either incorporation or a principal place where it does its business. And only then can you obtain general jurisdiction, which means regardless of what the cause of action is, if they're at home in that particular jurisdiction, you can sue them there. And that is relevant a lot of times in products cases because a number of manufacturers have over the years incorporated in Delaware, so that one could look to Delaware if you wanted to, regardless of the fact that the case occurred in Pennsylvania, if the manufacturer is incorporated in Delaware for general jurisdiction. And sometimes that's necessary because you may not have what we're about to talk about here, which is the criteria for specific jurisdiction. And specific jurisdiction, as the United States Supreme Court decided very recently in a case called Ford Motor Company versus Montana, that dealt with when you can get specific jurisdiction over a foreign manufacturer. And by foreign, we're talking about any manufacturer that is not incorporated within Pennsylvania, okay? So that's what they mean when we talk about the jurisdictional definition of a foreign manufacturer. And so if, for instance, in the Ford case, they're obviously not incorporated in Montana. The accident occurred in Montana, but the product was not sold by Ford in Montana. And because of that, Ford argued that the courts of Montana did not have specific jurisdiction. Now, clearly the plaintiff in that case could have sued Ford in either Michigan or Delaware because they're incorporated there, because that would have general jurisdiction. So I just want you to understand that concept, and then we'll move to specific jurisdiction. Here, what happened was Ford simply said, look, we do business in your state, but this particular product was not delivered by us to Montana, and therefore you do not have specific jurisdiction over us for this incident. And the U.S. Supreme Court took that case because there have been an evolution of logic by the court on specific jurisdictions, starting and primarily with the case involving a multi-district litigation of drugs in Bristol-Myers. There's a case called Bristol-Myers, which was went to the U.S. Supreme Court. It was a multi-district litigation in California, and there were California plaintiffs who had taken the drug in California, but there were also a whole group of plaintiffs from New Jersey that had filed in this multi-district case in California. And while the California Supreme Court had said that it had jurisdiction over all the parties because the product was sold in California, the U.S. Supreme Court distinguished between the California plaintiffs and the New Jersey plaintiffs. And in that case said, no, you do not have specific jurisdiction of the New Jersey plaintiffs, that the fact that the product is sold in California is not sufficient when the injured party lives and suffered the harm in New Jersey. So that then raised all kinds of flags for defendants like Ford to argue that there's no specific jurisdiction, for instance, in Montana, because the product was not sold by them in Montana. So the Supreme Court had to square that decision, the Bristol-Myers case, with the Ford case. And it did so easily. And it went back to the worldwide Volkswagen case and said, look, we've been saying this for decades and we're not changing. And that change is when you manufacture your products all over the country, if one of those products ends up in Montana and causes the injury, as long as you do business in Montana, substantial business in Montana, then there will be specific jurisdiction. And it doesn't have to connect specifically to the product that would cause the harm. As long as there's sufficient evidence that you market there, you intentionally market there, and you market this product there, even though the accident product was not sold by you in that state, it's foreseeable. And consequently, there's nothing unfair about obliging you to answer questions in a court in Montana. So it stopped the bleeding, if you will, in terms of jurisdictional issues for U.S. companies that market all over the United States. Okay, it stopped the bleeding. But again, you know, it still raises some other issues. And those issues I think that we're going to see in the future that will have to be resolved deal with foreign corporations, meaning foreign to the United States. You know, we know, obviously, we all experience this, that many, many products that we enjoy in this country are manufactured in other parts of the world. And so, and manufacturers are not stupid. They have lawyers and they have set up systems like I'm showing you here, where either you have Corporation A that does, let's say they manufacture the product in England. And then what they do is they don't ship it here. They have a subsidiary, a wholly owned subsidiary with their own bookkeeping that then is a US subsidiary that gets the product in England. Or they have a distributor from England that's unrelated to them to ship the product here. Then when the product gets here, the subsidiary is responsible for shipping it all over the United States. And based on that kind of a scenario, they say, hey, we don't do any business here. You cannot subject us to jurisdiction, specific jurisdiction, regardless. And that has come up. It came up years ago in a Third Circuit decision, even before the Ford case. In this case that I've cited here, I believe it's pronounced Dejamos or Weinberg versus Pilatus Aircraft. And it was a Swiss aircraft manufacturer. And again, it had its American subsidiary distribute the product. But the court found that since the subsidiary's functions were just to do the bidding of the foreign manufacturer, that it would have specific jurisdiction. over the foreign manufacturer. Now, that's tricky, and there's a lot of cases that have, at least in trial courts, distinguished that even though it's a subsidiary, when it's a subsidiary, and even though it's a wholly owned subsidiary, if they do things on their own and there's not this connection, you may not be able to get jurisdiction over the foreign company. So it really does become fact dependent. And one of the cases recently, post the Ford case, is this case, Rickman versus BMW, which was decided this year in a federal court in New Jersey. And there it said that we can obtain specific jurisdiction over BMW AG. And that's important because most of the foreign car companies operate the same way as BMW AG does, as I described a moment ago. And that is, it's a wholly owned subsidiary, but they've got their own board, they've got their own officers, you know, they do their own work. And you'd have to get into their bookkeeping to ever figure out how much of what is earned by BMW NA is actually then provided to BMW AG. And believe me, you can figure it out if you get yourself a forensic accountant and spend a lot of time. And the court said, look, as far as I'm concerned, one only operates for the other, okay, period. I mean, BMW AG has this huge investment in the American market. And because of that, there's no question that they have distributed their products here with the intention of doing substantial business. It's not random. It's done on a regular basis. And that's what the Ford case says for a specific jurisdiction. And so the court analyzed this and said, yes, we think there is sufficient evidence that the defendant, BMW AG, is connected to NA and that specific jurisdiction should be allowed. Now, in that case, I believe the court said, you've made a prima facie case, but now you got to go back and do some discovery, okay, to convince me that I'm right, the court's right on that issue. But I don't think there's much difficulty in doing that. The question is whether or not it's worth the effort. And that you can only determine in an individual case, because there may be some cases where you just don't need it. If you have the distributor and they have sufficient insurance, it really may not matter, okay? So it's going to depend on facts. It's going to depend upon what proofs you need to make in order to prove your case. Now, Pennsylvania has, of course, the same kinds of laws regarding jurisdiction and specific jurisdiction to the full extent allowed by the Constitution. But we have another clause, and that is the registered to do business clause. And under Pennsylvania law, if a manufacturer is registered to do business in this state, that bestows actually general jurisdiction on the courts in our state. Now, that's the Webb case. But I must tell you that I believe there's a case in the Pennsylvania Supreme Court, not Webb, but another one since then, which is looking at this issue, because there have been challenges around the country on whether or not the statute bestowing general jurisdiction is permissible under the Constitution. There are only a few states in the United States that allow for this. Georgia happens to be one, and I know that because I've written an amicus brief there in their Supreme Court on this very issue, and whether or not this is constitutionally permissible. The U.S. Supreme Court, in the Ford case, in a footnote, referenced that there are some states that allow for general jurisdiction based on registering to do business, and it did not really comment on that. It simply mentioned it in passing. So it's an open issue. I think the U.S. Supreme Court decides in some instances, let's not touch this until we have to make sure that we're guaranteed to have business in the future. But they did not touch it. But right now, if a foreign corporation is registered to do business in Pennsylvania, that bestows general jurisdiction, and you don't have to worry about specific jurisdiction, but you will have to worry about preliminary objections and an appeal. Let's talk about venue. Let's move on to venue. Venue is a big issue, obviously, in Pennsylvania, because we all want the demographics of our jury to be as favorable as possible. And as we all know that practice, certainly in the Philadelphia and Pittsburgh area, that, you know, it's always a big issue. We want to be either in Allegheny County or Philadelphia County, and the defendants want us anywhere else but if it's possible. So if the accident occurred somewhere else, you know, we can file in Philly or we can file in Pittsburgh, but they're going to try and remove us or transfer us to another venue. The laws and the cases have been pretty good in our appellate courts on venue. As long as you regularly conduct business, the defendant conducts business there, even if the incident occurred somewhere else, you can file in Philadelphia. You've got to be prepared for the challenge. And when the challenge comes, you got to know the law and you got to have the facts as controlled as you can when you submit your brief. And so what we have to look at is whether the manufacturer has sufficient quantity of business and quality of business in Philadelphia. And it doesn't take much, but it just takes some. But I'll give you an instance where it's a problem, but it's a problem you can overcome. For instance, I've filed a suit a couple of years ago against Honda in Philly. And wouldn't you know it, the Honda comes in and says, we don't do any business in Philadelphia. We don't have any retail outlets in Philadelphia. We don't do anything here. And so it was a real, and of course the accident occurred not in Philadelphia County, but somewhere upstate Pennsylvania. Now we had to go through a whole rigmarole with factual evidence to convince the court that that they do business in Philadelphia, that their marketing practices, their dealerships extend to Philadelphia. They have recalls where they contact all the customers that live in Philadelphia, et cetera, to get that done. So, but that's going to be a challenge. It's going to be a challenge. And I'm not talking about forum nonconvenience yet. I'm simply talking about complying with the venue statute, that is in quality and quantity. And this is just an explanation of what's meant by the quality criteria and the quantity criteria. And it's not very big. I mean, quantity simply means that they have continuous contacts and substantial contacts. Quality is a rather nebulous thing. These cases talk about, well, if you do 3% of your work in Philly or 5%, that's good enough. So it's really very simple to meet in most instances. What's more challenging is forum nonconvenience. And here, again, you know, if I've got a case where the accident occurred in Monroe County, but I'm going to sue Mazda, I'd rather be in Philadelphia. Okay, no offense to Monroe County, but that's not where I want my case to be venued if I can afford it. And so what I've got to do is I've got to demonstrate that it's not inconvenient and that it's more convenient in Philadelphia. Now, if I've got a Monroe County plaintiff, again, this is a big challenge. And then if I've got to talk about why it's more convenient. Typically in products cases, the emphasis has to be on the experts in the case are not in Monroe County. They may not be in Philadelphia. They may not even be in this state. But wherever they are, their meter starts running when they get on the plane or they get in their car when they land in Philadelphia, and it's going to be cheaper, less expensive for us to be in Philadelphia. That's a primary one. The second one, I always get affidavits. I call them affidavits of convenience from fact witnesses who will say, okay, I'm a cop up in Monroe County. If you need me in Philly, I'm happy to come. Just let me know when. And I have these affidavits so that when they talk about inconvenience, we file with the court these affidavits of convenience to prove that Philadelphia is appropriate. Okay. The next thing I want to talk about real quickly is one of the primary defenses in products liability cases. It's called federal preemption. These come up in filings typically with car companies and with other products that comply either with federal motor vehicle standards or consumer product safety standards. And the argument is we've complied with the standard and you cannot bring a lawsuit against us because your lawsuit would be in conflict with our compliance with the standard. It is a very sophisticated argument, typically only raised these days in some motor vehicle cases. because the U.S. Supreme Court has pretty much clamped down on the preemption defense. And we're not seeing it. The cases I've cited all deal with preemption regarding either drugs or ABS brakes, or actually a propeller, which is the Spearsma case, and airbags. So it's an issue that does come up not regularly. The last time the Pennsylvania Supreme Court dealt with it in the context of a motor vehicle goes back about 30 years in a case called Salucci versus GM. Which was one of my cases and was at a time when we were suing for failing to include frontal airbags. And that got caught up in the U.S. Supreme Court decision of Geyer versus American Honda, which is the last time the U.S. Supreme Court ever has preempted a motor vehicle design claim. Since then, the cases have been much more consumer protective. It comes up occasionally in cases that we'll talk about on another session dealing with autonomous vehicles and collision avoidance systems, but I think that has also died down and hopefully will not raise its ugly head again. I want to talk, now we're going to move into, and I'm going to let Jaime talk a little bit about causes of action and duties under strict liability law.
Thanks, Larry. Excellent discussion on some pretty weighty legal topics, jurisdiction, venue, and preemption, and things that we certainly want to keep in mind and not be blindsided by before we file the complaint. Because you file the complaint, and then you get preliminary objections on jurisdictional issues and say, hey, you don't have jurisdiction over us. So it's just things that we always need to be mindful of and think about and whatnot in terms of filing these cases. And thank you for sharing that with us. So we talked about cause of actions last time, design defect, manufacturing defect, and whatnot, and duty, right? And does the defendant have a duty, and negligence and whatnot? So the duty, we talked about the designer, manufacturer, suppliers, and anybody in the chain of distribution and whatnot is a potential defendant and whatnot. The vendor, who's the vendor that owes the duty? Really anyone in the chain of distribution. Now you had, Larry, which is an interesting case, the Schimmel case versus Navistar, that is, I think, going to be a number of cases we're going to see along these lines in the future. And that case involved you can tell us about it, the truck that involves crash avoidance technologies and the failure to put and equip this truck with crash avoidance technologies. So what do you learn in that case that's going to be helpful for us going forward? Because I think this is going to be a new area.
Sure. I mean, the issue that the court addressed there was, because we sued both the manufacturer and the distributor of the truck, and it was a very large distributor, nationwide company that buys these trucks from the manufacturer and then sells them as new products to truckers all over the country. And what we found was that the manufacturer was offering to the distributor equipment, different kinds of equipment for the trucks to be manufactured with, including collision avoidance safety systems, radar systems. And the distributor then chose not to add to the trucks they were purchasing from the manufacturer these safety features. And our argument was that not only did the manufacturer have duty, but so did the distributor. And the distributor's duty was to know what was available to make the product safer and to equip the vehicle with those safer systems. And the court found, yes, you do have a duty. Whether or not the jury decides that you're responsible for failing to equip is for the jury. But you do have a legal duty to determine if the vehicles are safe with or without these optional features. And if it's not sufficiently safe, to put them on before you sell the product.
In terms of who the duty is owed, like for example, in that case, or use that case as an example, if it's another passenger on the roadway who is injured by that product, there's a duty to that person because it's foreseeable. And that's still the test under the restatement second and whatnot, that it's foreseeable that they could be harmed by the product. That person did not own the product. They were not the purchaser of the product.
No, he happened to be a motorcyclist coming the other direction when the truck came across the road in front of him. Yep.
And those innocent third parties are still owed the duty, the manufacturers, to manufacture safe products that will not harm all of those other people. So bystanders and innocent bystanders, let's talk about that a little bit. And tincture did not change the law or address bystanders and whatnot. And they're still owed a duty in terms of manufacturing safe products. And that's still the law in Pennsylvania. That has not changed. And another thing that has not changed, and tincture did not change, is contributory negligence and comparative fault in products cases. Let's talk about that. The general rule is still the plaintiff's contributory negligence and comparative fault is not a defense in a strict liability claim. Tincture did not change that. That issue has been addressed in a couple of federal court cases, and we'll give you those cites to the Divex case and the other cases that address that. So that is still the law in Pennsylvania, except, and there's an exception to every rule, right? Unless on causation, on the issue of causation, not defect, on causation, if the defendant can prove that the plaintiff's conduct was the sole cause of the harm. And they need to allege and show highly reckless behavior, just totally unforeseeable and extraordinary, which is a pretty high bar. And that goes to the issue of causation, not defect. What we'll see and what you may expect to see defendants argue going forward since tincture is, well, the plaintiff's conduct is admissible under the risk utility test and under specifically the fifth factor of the risk utility test, which is the user's ability to avoid danger. The defendants have been making this argument, and we shouldn't let them get away with it because it's not correct under the law. The restatement of second is still alive and well. It was embraced in tincture. The risk of harm still is focus remains on the product and on the manufacturer. And this issue has been addressed again in a couple of federal court cases, the Divex case, the Rapcheck case, and is still very good law in Pennsylvania. That has not changed. So strategically, you may want to plead both negligence and strict liability in your complaint, but at some point you may want to drop the negligence claim because the comparative negligence or contrib is not admissible in a strict liability only case, but obviously it would be if there's negligence and whatnot. So strategically, you want to think about that. The next, we have the law on comparative and contributory negligence. We'll give you that. So let's talk about another defense, which is compliance with standards and regulations, right? Well, we met all the government standards, or we met the federal motor vehicle safety standards and whatnot. Again, tincture did not change any of that. They are still inadmissible, going back to, the Harsh case versus General Motors, the Gaudio versus Ford Motor Company, that was Larry's case, and got a nice opinion from the Superior Court that said no, compliance with standards and regulations is not admissible in a strict products liability case. And that is still the law in Pennsylvania. Nothing has changed that.
Let's, and Jamie, so that we bring this full circle, we have this Superior Court decision that was just rendered within the last month in the Sullivan versus Werner company case, which is a scaffolding case where the scaffold collapsed. And that court actually then decided and looked at tincture, because that's what the manufacturers argued. They argued, wait a minute, tincture changes all this. Now tincture is more negligence than it is strict liability. That alters the issue of admissibility of standards or industry practices, and also comparative fault. It changes all that because now you're using, in that case, they used the risk utility test. And so they argued, hey, factor 5, it's the user's ability. In fact, while they didn't mention it, the user ability really deals with only in the context if the user knows of the risk. Okay, so it really is a false positive, if you will. But this case is very, very, very important because it addresses these various issues. The admissibility of industry standards after tincture or comparative fault. And as to comparative fault, it reminded us what Jamie just said, and it didn't change the law. Tincture did not change the law on comparative fault. Here they were arguing that the person working on the scaffold did not put it together properly, and that's why it collapsed. But in fact, the plaintiff's claim was that the way it could be put together, and he did it appropriately, that's why it collapsed. So there was no evidence that he was the sole cause. Okay, and where he's not, and that's the comment here. The defendant cannot argue that the plaintiff's negligence was the sole cause unless it is unrelated to the product. That's the critical part, unrelated to the product. And so that was not proved there. And so the court's ruling on comparative fault and disallowing it was appropriate. Also, it excluded, and I think we have another slide later on, admissibility of state-of-the-art or standards of the industry, holding that Gaudio and Harsh and the other Lewis are still good law. Tincture hasn't changed it. The Superior Court looked at that in great detail and explained why, because tincture still says that a manufacturer is liable under 402A, and that 402A says regardless of the due care of the manufacturer, that there is liability. Therefore, putting in evidence of compliance relates to due care, and that doesn't come in under 402A. So they upheld our principled issues and conclusions under Pennsylvania appellate law. So let's talk a little bit, Jamie, why don't you talk a little bit about the Fair Share Act as it relates to products liability?
Yeah, the Fair Share Act, and I think we have some pretty good law on this in products cases. And the Fair Share Act, remember, key point of the Fair Share Act focuses on cases where plaintiff contributed to his or her own injuries. And then that's where the Fair Share Act comes into play, remember? And we just talked about that comparative or contributory negligence is not a defense in a strict products liability case. So the case that just came down, the Sullivan case that Larry just mentioned, is helpful for us on the contributory negligence standard and state of the arts. The Spencer case is helpful for us on the Fair Share Act because it clarified the intent of the legislature and said, look, the Fair Share Act does not apply when plaintiff did not contribute to their injuries. And in a products case, if contributory negligence, comparative negligence is not admissible, then it shouldn't apply in a products case and is not a defense in a products case. So I think that's very good for us. And if we have now, because the law was unclear, I'll use an example, the crashworthiness case as an example, where you have plaintiff's negligence and maybe multiple defendants. If plaintiff was not negligent and they're in a car crash, there is no, Fair Share Act does not apply if the plaintiff did not have any negligence or play any role in causing their injuries. So I think the law is good for us on that, and keep that in mind in product liability cases.
Particularly when you're in a mediation and someone talks to you about, well, your client caused this accident, or your client was careless in the way they operated this machine. Well, sorry, pal, that doesn't float. That's not a defense, and you're not going to get apportionment based on that claim. But Jamie, let's go back and talk a little bit about the state of the art and what that encompasses under Pennsylvania law.
State of the art, right? First of all, what the heck is state of the art? If you look at some of the opinions in courts, have different language. I mean, state of the art is a term, and we hear it in, engineering term, state of the art. But what is state of the art in terms of how courts have addressed it in opinions? And we see various opinions that talk about state of the art, discuss things like custom in the industry customs, government regulations and licensing standards, and then technological feasibility. And that's sort of what I think of when I think of state of the art. But the courts have been and used that terminology somewhat interchangeably. So kind of know that that's what all of those things mean. And the bottom line is, again, going back to the Character versus Colson case that stood for and affirmed that state of the art is not an affirmative defense in Pennsylvania. That's still good law. And Larry, you mentioned that this was addressed recently in the Sullivan case.
Right. So that's here where they looked at it in great detail. So it's a really well-written opinion where they had to address is state of the art, is state of the industry now admissible because of the language of the tincture opinion. And as they analyzed it, they said, look, tincture addressed Azzarello, and that's pretty much all it addressed. And remember that Azzarello is not the Lewis Supreme Court decision. It's not, and it doesn't deal with Gaudio. Those things were not overruled in tincture. So the question is, what is the impact of tincture having overruled Azzarello but not addressed this particular evidentiary issue? And so it had to confront the argument, well, wait a minute, tincture started talking about negligence and strict liability as part of negligence and all these arguments. And because of that, maybe, the defense of state of the industry, state of the art comes in. But the court said, no, we've looked at this, okay? And what we found is that tincture simply goes back, it's back to the future. It's 402A from 1965, okay? And it's still based upon the fact that under the restatement, it doesn't matter whether you used all possible care. It's still defective if it's, quote, unreasonably dangerous under two tests, either the consumer expectation or the risk utility. And so it concluded that under 402A, knowledge of the danger is imputed to the manufacturer. That's critical, okay? You can tell the jury in argument, this manufacturer, if you believe it was defective, guess what? They knew it was defective because that's the law, and yet they marketed it. It's imputed to the manufacturer. And so therefore, the issue is not what the manufacturer did to make it safe or unsafe, but whether it's safe or unsafe. And so the court concluded that under these provisions, that compliance with industry practice, state of the art, all that is doing is wanting to tell the jury, quote, sure, the product may be dangerous, but we did everything we reasonably could. We did what other manufacturers did, so you can't fault us. Well, that's due care. And that does not come in. That's still not the rule in Pennsylvania, that this is not admissible evidence. Okay, let's move on then, Jamie, to some practical issues. For instance, the product.
Right. Spoliation. Let's talk about that. And we'll talk about spoliation a little bit more next time when we talk about investigating and identifying products cases. But let's talk about it here since we're talking about defenses today. Spoliation as a defense. But I must say, my general rule is, look, in a products case, no product, no case. How are you going to prove your case without the product, you're really going to have an uphill battle. I suppose there are times maybe in the right case, in a design case, under the right circumstances, and I guess I've violated this rule once or twice in my life, and it was always somewhat regretted it because I'm like, how did I get here? What am I doing here? But without the product, no product, no case really, because you really need the product to prove the case. Sometimes not in a design case, but spoliation as a defense. Let's look at what the defendants would have to establish in order to either get an instruction on spoliation or potentially have the case thrown out on summary judgment. And the first one here, I think, is the key inquiry, and that is, was the product within the party's control? Did the plaintiff own the product? Was the plaintiff in possession of the product post-injury? A lot of times, for example, in an automobile case, a car crash, if you're considering bringing an auto products case, crashworthiness case against auto manufacturer, the plaintiff never sees the car again after the crash, potentially. The insurance carrier owns it, the plaintiff's in the hospital, and it's in the salvage yard, and it's never in their possession. So maybe in those circumstances, maybe, but again, it's just, if you can avoid that, and if you can do whatever you can, if you get the case early on enough to just make sure, get the product.
Yeah, I'll give you an example, Jamie, of one that I won recently. It's a motorcycle case against Yamaha for failing to equip the vehicle with ABS brakes. And my client could not stop in time to avoid a vehicle that came out in front of him. And he's now quadriplegic. And so we sued Yamaha for failing to equip with ABS brakes. And that case is still pending. And they filed a motion for summary judgment because the motorcycle's gone. The wreckage is gone. I mean, the motorcycle in the crash was basically split in half. And it went to a junkyard. And by the time we got involved in the case, it was gone. And actually, what happened was the insurance company went to my client's mother and got her to sign off on selling it for junk. And it's gone. And so Yamaha came in with a huge motion for summary judgment with all kinds of affidavits explaining that without the motorcycle, there's no way to know what the condition was of the brakes ahead of time or at the time of the accident. And, there are all these other things you need it for. And we had to battle that with our own experts to explain that in the design case, it's irrelevant. Okay, we've got some photos in the junkyard where it's split in half. There's nothing to prove here. The ABS system is independent of any maintenance issue. And it would have functioned if designed into this vehicle. And we were fortunate to have escaped that. And the question, of course, still remains, am I going to get is there going to be any kind of an instruction, even if it doesn't get dismissed? What would a court look at to decide whether or not there should be any instruction or any sanction against the plaintiff?
Yeah, the first hurdle, right, is, are we going to get past preliminary objections? Are we going to get past summary judgment because we don't have the product? And then the next issue, or the next issue in your case, Larry, or in a case where you don't have the product, is, okay, what are the potential ramifications of that? Or sanctions is a strong word, but that's it, right? What are the ramifications of it? And it can be anything from nothing. If you have a totally innocent plaintiff who never had possession or control of the product, there's no bad faith. You have a child who was in a child seat, maybe something like that. Anything from nothing all the way to having the case thrown out on summary judgment because you don't have the product, or things in between, like an adverse jury instruction or adverse inference to the jury instruction on spoliation, and that the jury may draw an adverse inference from the fact that the product is not there. And there's factors that the court looks at in determining the extent of the sanction, if any, and those are your 6 factors there that the court would look at, and there's case law on that, but it really comes back to the extent of, in Larry's case, for example, because that's a good example, and what we would argue is like, look, our guy's in the hospital. He didn't do anything intentional here. He never had possession of it. His mother didn't know. There's no bad faith, dilatory tactics going on here to hide evidence. That's just the nature of the process that happens a lot of times when you're in a car crash and accident and the evidence isn't preserved. But these are the factors that they look at in order to determine really anything from tossing the case out to getting adverse inference to hopefully nothing, and move the case forward with that.
Okay. Well, that's great, Jaime. Thanks. So this completes our second program. And as Jaime mentioned, the next program we will spend identifying product liability cases, in which Jaime and I will spend time reviewing a whole host of different kinds of cases and talk about the factors that we at least account for, both from a factual standpoint and a legal standpoint, in defining what cases, particularly with people that are very seriously injured in wrongful death cases, should pursue, and what are the elements of these cases from both a legal and factual standpoint in deciding what cases to take and what cases not to take based upon our own good and bad experiences. So thank you, Jaime. Appreciate it, and I enjoyed this.
Yeah, me too. I'm excited for the next one. That's an interesting topic and a fun topic, and one of the more interesting and exciting parts of our job in investigating these cases. And I'm excited to talk with you and the others about that next time. Looking forward to that one.
Okay. All right, Jaime. Take care. So long, everyone.
Take care.
Bye-bye.